Hello guys, I'm Shreya and I welcome you all to my channel Knowledge Info. Today in this video we will be discussing about one of the most important topics which you need to know is the daughter's right on property as per 2023. Yes, in today's video we will be discussing this topic in detail. So before discussing this topic, we need to understand the basics of Hindu Succession Act 1956. We need to understand this section in greater detail in order to understand the implication of daughter's right on property. Then we will be discussing that whether the amendment which was made in the Hindu Succession Act 1956 brought any major change in the daughter's right on property. We will understand all this with the help of the referring case laws and the leading judgments, under which we will pay a particular focus on the following two case laws, which are as follows: Vineeta Sharma versus Rakesh Sharma and others, which was passed in the year 2020, and Arunachala Gounder versus Ponnuswamy, which was passed in the year 2022. So after discussing all these points in detail, we will understand that what right does a daughter possess on the parental and ancestral property and what are its impact and implications. So stay connected till the end in order to gain proper information. So without further ado and blabbering, let's move towards our video. So at first we will be discussing about the Hindu Succession Act 1956, under which we will be talking about its meaning and objective. Let's begin. So basically, Hindu Succession Act 1956 deals with the property's rights and inheritance. This act gives a broad view of who can be given the property and the rights available for both males and females while acquiring a property. This is the basic meaning and objective of the Hindu Succession Act 1956. Now, we will be talking about the applicability of Hindu Succession Act 1956. The applicability of Hindu Succession Act 1956 is given under Section 2 of this Act, which talks about the applicability of this law. This law is basically applicable to anyone who is a Hindu, Buddhist, Jain, Sikh by religion, and also to any other person who is not a Muslim, Christian, Parsi or Jew by religion. This law is also applicable to any other person who does not follow any other religion. But this section is not applicable to the scheduled tribes covered under the meaning of Section 366, Clause 25. Now we will be discussing about the usage of the Act. The Hindu Succession Act 1956 comes into force when a Hindu male dies intestate in India, that is, without leaving a will. The devolution of his property upon his heirs is done by the rules specified under the Hindu Succession Act 1956. This act was basically made to amend codify the law relating to intestate or unwilled succession among Buddhists, Jains, Hindus and Sikhs. Now we will be discussing about the kinds of property which comes under Hindu Succession Act 1956. According to Hindu Succession Act 1956, there are two kinds of property. First is self-acquired property and the second is coparcenary property. Self-acquired property is basically such a type of property which is not inherited by any of the forefathers or ancestors. These kind of properties are bought by an individual with his own earning and without the assistance of family funds. The property which is acquired through a will is also a self-acquired property. And the second is ancestral property or coparcenary property. As the name suggests, this property is basically such a type of property which is inherited by a person from his forefathers or ancestors. This kind of property is passed down from by 4 generations of the male lineage and the property should be undivided during this time, which means that the property should be undivided till the time it is being passed down to the person concerned. Now, let's discuss about the scope of the Hindu Succession Act 1956. The scope of this act covers the division of ancestral property in a Hindu joint family. But in a Hindu joint family, there are members and coparceners both. So the question arises, what is the difference between the two? It means that the question arises that what is the difference between members and coparceners? Whether both are same or there is a difference between the two. So let's discuss. The basic structure of any Hindu joint family comprises of the Karta or the head of the family, his wife, his son, his daughter, daughter-in-law, son-in-law, grandson, etc. All of them are members of the family but not co-partners. It means that there exists a difference between co-partners and members. So now let's understand that what is the meaning of the term co-partner before understanding that what is the difference between the members and co-partners. So basically, co-partners are those individuals who can claim their right on the ancestral property. It means that these are those individuals who have the right on the ancestral property and at the same point of time they can demand for the partition. For example, when a person owning an ancestral property dies, the property would by default pass down to his son, grandson, great-grandson and so on. So basically it talks about the survivorship rule. Section 6 of the Hindu Succession Act 1956 deals with this aspect and was also known as the survivorship rule, which says that only male members were allowed to be co-partners. Before the amendment of 2005, only male members were allowed to be co-partners, which means that apart from the holder of the property, his next 3 generations, particularly male, were allowed to become the co-partners and have the right to claim for the partition of the joint property or the ancestral property. Now, let's talk about the criticism of the Hindu Succession Act 1956. Or in particular, if I say, let's talk about the loophole of Section 6 of Hindu Succession Act 1956. The main criticism of Section 6 of Hindu Succession Act 1956 was that the survivorship rule allowed only the male lineage to be co-partners. As I told you, only the male members were allowed to become the co-partners of joint family property. The women were not given equal rights over the property, and this was quite discriminatory in nature. Although the Hindu Succession Act 1956 did say that women would have equal rights over the property, but the Mitakshara law of co-partner did not allow females to become co-partners of the property. Therefore, in order to remove the loophole or the criticism of Section 6 of the Hindu Succession Act 1956 and to provide equal status to women in society and in joint family property, the amendment was made in the Hindu Succession Act 1956, which was the 2005 Amendment of Hindu Succession Act 1956. The Hindu Succession Amendment Act 2005 was assented by the President on 5th of September 2005 and it came into effect from 9th of September 2005, which means that the date of its enactment is 9th of September 2005. This amendment was brought to end about the discrimination in the Hindu Succession Act 1956, that is, amending the Section 6 basically, thus abrogating the survivorship rule. Under this amendment of this section, if a person dies intestate, the property would be inherited to class 1 heirs, which consists of the widow, son and daughter of the deceased, and the property would be equally divided among them. In the absence of class 1 heirs, due to any reason, then the property would pass down to class 2 heirs and so on. This act also amended the Section 4, Section 23, 24 and 30 of the Act. So basically, this Amendment Act provided amendment in Section 6 of the Hindu Succession Act 1956 and stated that daughters are co-partners since birth and will have the same liability as that of a son since birth. After the amendment of the Hindu Succession Act 1956, Section 6 was amended and the survivorship rule was abrogated or abolished. In place of survivorship rule, types of succession came into place, which includes 2 types of succession: testamentary succession and intestate succession. Testamentary succession means when an individual's property is divided on the basis of a will made before his death. This kind of succession is called testamentary succession. Testament basically means succession through will. Under the will, the person is allowed to pass down his property to anyone he wishes. Apart from the family members also, if a person wants to transfer his property, he is free to do it. And the second is intestate succession, which means when a person dies without creating a will or without making any testamentary disposition of his property, then his property will be divided following the rules of the Hindu Succession Act 1956. In case of males, If a male dies intestate, that is without making any will, the property would go to class 1 heirs. This basically consists of the deceased wife, son, daughter. They would have the very first claim on the property. In the absence of these heirs, the property will devolve into class 2 heirs, and in the absence of class 2 heirs, the property will go to class 3 heirs, and in the absence of class 3 heirs, the property will go to class 4 heirs. In the case of females, if a female dies intestate, the very first claim of the property would go to her husband, son, daughter. In the absence of them, the property would go to the heirs of the husband. The property would pass down to the parents of the deceased in absence of the above mentioned claimants. The fourth claimant of the property would be the heirs of the father, and the fifth claimant of the property will be the heirs of the mother. This amendment was brought as a solution, and it was declared that daughters also have an equal right and liability in the father's property, just like the sons, and daughters are entitled to this right since birth. But in spite of this clear decision, even then there were certain confusions behind this act. Though this act was brought about as a solution, but there was still certain confusion surrounding this amendment. The main question was that, will this law be applied retrospectively, or it is applicable for future cases only? This meant that if a person died in 2002, that is before the enforcement of this amendment, would the daughter still be entitled to the property, and would she be a co-partner? So as an answer to the previous question, we will be discussing certain cases which solved this confusion to the maximum extent. First, we will be discussing about the case of Prakash and others versus Phoolwati and others, which came in 2016, dealt with the above question that whether this law will have a retrospective effect or not. This case was headed by a 2-judges bench, Justice Anil Dave and Justice A.K. Goyal in the Supreme Court, and they held that the rights under this amendment would be available to those daughters whose fathers were living on the date of enforcement of this amendment. This has been declared as a landmark judgment, for it held that only living daughters of living co-partners are entitled to the property. The second case regarding the same question came up in the year 2018. In the case of Dhanamma versus Amar, the Supreme Court was headed by a 2-judges bench, Justice A.K. Sikri and Justice Ashok Bhushan. This time held that the rights under the 2005 amendment would be applicable to the daughter even if the father is not alive on the enforcement date of the amendment, thus making both the daughters and sons equally liable for the property, and this right is given to both of them since birth. Even though in 2018, the judgment was passed in favor of daughters having equal rights over the father's property, there were still some confusions as to whether to follow the 2016 judgment or 2018 judgment. Finally, in the case of Vineeta Sharma versus Rakesh Sharma, put an end to all these speculations surrounding the applicability of this amendment. The earlier cases were headed by a 2-judge bench, but in this case it was headed by a 3-judge bench, and they are Justice Arun Mishra, Justice Abdul Nazir and Justice M.R. Shah. The Supreme Court in this case clearly said that daughters and sons have an equal liability over a property, and that this right is given to them since birth, and whether the father is alive or dead, it doesn't affect the right of the daughter. But even after the judgment of Vineeta Sharma versus Rakesh Sharma case, there were still certain confusions in the minds of the people which were cleared or which were resolved in the case of Arunachala Gounder versus Ponnuswamy in the year 2022. So let us discuss about the issues which were dealt in the case of Arunachala Gounder versus Ponnuswamy 2022. Can daughters inherit the self-acquired property of their father who died intestate or dissolves on father heirs through survivorship? Answer to this question is that daughters of a male Hindu dying intestate, that is without making a will, would be entitled to inherit self-acquired and other properties obtained in the partition by the father, and it has the retrospective effect, which means that the existence of father makes no effect or makes no change to it. And the second issue is, upon whom will the property of a female dying intestate dissolve? It means that if a female died without making any will, her property will be devolved to whom? Issueless Hindu female dies intestate, that is without making a will. Then her property would be devolved to her father heirs if she inherited the property from her mother or father, and the property would be devolved to her husband's heirs if the property is inherited by her from husband or father-in-law. Now, let us discuss the facts of this case in brief. In this case, Ponnuswamy Gounder inherited the property from her father Maratha Gounder. Now, according to this judgment, the property must be devolved to her father's heirs as she inherited the property from her father. Father heirs means that the property must be devolved to the sons and daughters of father's brother. So accordingly, the property must be devolved to Ramse Gounder's daughters and sons. The basic motive of judiciary and legislature behind this was that the property must be returned back to the same source from where it is derived. That is, Ponnuswamy Gounder inherited the property from her father Maratha Gounder, so after her death intestate, the property must be returned back to the father, that is, the property must be returned back to the source. Therefore, in January 2022, it was collectively being held by the Apex Court through its decision in Arunachala Gounder vs. Ponnuswamy Case that the self-acquired property of a Hindu male dying intestate would devolve by inheritance and not by succession. Further, the daughter shall be entitled to inherit such property as well as such property obtained through the partition of a coparcenary or family property. It was also observed that in case a woman dies intestate, then the ancestral property devolved on her from her father would be bestowed upon her father's heirs, and the property devolved on her from her husband's side would be assigned to her husband's heir in case she died issueless. Now, let's summarize what we studied so far. So, before 1956, that is, before the commencement of the Hindu Succession Act 1956, the Shastric and customary laws varied from region to region and governed the Hindus. Sometimes it varied in the same region on a caste basis. And after 1956, that is after the enactment of Hindu Succession Act 1956, till the commencement of Hindu Succession Amendment Act 2005, ancestral property was to be dissolved by the survivorship rule and not by the concept of testamentary or intestate succession. Only males were the coparceners up to 3 generations at that point of time, and women were not recognized as coparceners. After the Amendment Act of 2005, in the Hindu Succession Act 1956, amendment was made in Section 6, which abrogated the survivorship rule and gave right to the testamentary and intestate succession. Daughters were not recognized as coparceners, and they have the same rights and liabilities as that of a son. We have also studied certain case laws such as Prakash vs. Phoolwati, which stated that father has to be alive at the date of enforcement of 2005 amendment. Subsequently, the daughters can claim benefit under 2005 Act. Then we have discussed about the Dhanamma vs. Amar Singh case, which stated that the father may be died before 2005, yet daughters will get equal share. Daughters are entitled to their coparcenary property since birth. Then we have discussed the most important case, which is Vineeta Sharma vs. Rakesh Sharma Case, which disagreed with the 2015 judgment and further stated that father need not to be alive at the date of enforcement of 2005 amendment. Now we will be discussing about the impact on daughters' right on property. After the amendment of Hindu Succession Act 2005, daughters will now be treated at par with sons of coparceners and granted equal coparcenary rights in their father's property upon birth itself. Daughters shall remain coparcener throughout life, irrespective of whether their father is alive or not. Hence, even their marital status will not affect the rights conferred to them by way of the amendment, and hence they shall continue to be part of their father's Hindu undivided family post-marriage. The door of alienation of their share of property will be opened for daughters without any ambiguity. Ambiguity means something which is unclear. Daughters can now seek partition of their father's coparcenary property and can claim their equal share as that of their siblings and other coparceners and cannot be denied on the basis of an oral family settlement. So with this, we ends up with our video. If you have any suggestions regarding my video, do let me know in the comment box section, And if you liked my efforts which I tried to pour in this video, do like, share and subscribe to my channel. Don't forget to press the bell icon parallel to the subscribe button in order to get notified when I will upload my further videos. So it's the time to leave now. So until we meet again, stay home, stay safe, do take care of yourselves, do take care of your families, and there's a goodbye. Thanks for watching.